Hello, hello. Good afternoon. This is Misha Janice. We have been following the appellate story in Charlie Adelson's case. Charlie Adelson, who was convicted, of course, for his role in the murder of Dan Markel. We most recently saw that he and his attorneys filed this motion to relinquish jurisdiction to the appellate court, requesting that they allow Charlie to go back to state court, sorry, back to the trial court, so that Judge Everett can determine if he received a fair trial, basically. You guys hang in there with me. This is my second time recording this, and I'm running out of time. So I want to make this as short and sweet as possible. So I checked today and there was a response from the state on the docket. It wasn't available earlier. Apparently, they filed it 2 days after the motion to relinquish was filed, but it wasn't available for public viewing until today. We have the document now, so we're going to go through it. However, before I do that, I want to do a quick TLDR. And this is specifically for those people who don't have time for an entire reading through of a 15-page document. So basically, the state argued, this is the TLDR, guys. This is the state's argument, sort of in a nutshell. They argued that Charlie's motion should be treated as a post-conviction claim of ineffective assistance of counsel under Florida Rules of Criminal Procedure 3.850, because no grounds were given for the motion, but the contents of the motion basically claiming ineffective assistance of counsel, that would fall under this particular Rule 3.850. Now, let's turn to their arguments against the actual motion itself. They argue that Charlie failed to plead that there was any fundamental error, namely that Rashbaum's conflict of interest caused the jury to convict Charlie rather than acquit him. All of this would kind of be inconsequential if it was just, some small error. So they have to at least show that there is a fundamental error in what happened in the trial court in order to have anything done related to overturning a conviction. The state also argued that the court should not exercise its discretion in relinquishing jurisdiction back to the trial court. They said that Charlie's grounds for his motion is speculative and frivolous because basically he didn't show that Rashbaum had an actual conflict, and the motion also didn't explain why it wasn't being brought as a post-conviction motion, as opposed to the fact that he's already in appellate court, and a post-conviction motion in appellate court is not the correct procedure. They go on to expand on how there was no actual conflict and discuss the waivers and the facts of the stipulation that I posted about on my community page. That entire stipulation is posted there from a couple days. If you haven't seen that, go ahead, go check that out. The state then went on to cite to a case where no actual conflict was found, where an attorney represented co-defendants, where their testimony was compatible and not contradictory. So they went to great lengths in sort of detailing how Charlie and Donna's testimony probably wouldn't even contradict each other, since the testimony of Donna was going to be used to support Charles Adelson. So let's turn to the motion right now. It is a 15-page motion, and I'm just going to read it through, and then I have to bounce. I have to go get my child. So let me share my screen. this a little bigger for you guys. All right, state's response to appellant's motion to relinquish jurisdiction to the trial court. Okay, Charles Adelson has filed a motion to relinquish jurisdiction to the trial court in Leon County. While Adelson's motion is unclear as to what specific proceedings he seeks in the trial court below, Adelson appears to be pursuing a claim of ineffective assistance of counsel while his appeal is pending. The state objects to Adelson's motion to relinquish because it is procedurally barred, and Adelson has failed to demonstrate a valid reason to circumvent the normal procedures for post-conviction relief under Florida Rule of Criminal Procedure 3.850. Issues presented. Charles Adelson's motion presents two issues for this court to consider. First, can Charlie Adelson pursue his conflict of interest claim while his direct appeal is pending? Second, if Adelson can pursue his claim during the pendency of this appeal, should this court exercise its discretion to relinquish jurisdiction to the trial court? Procedural history. A jury convicted Charles Adelson of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Attorney Daniel Rashbaum represented appellant Adelson during his trial. After Charles Adelson was convicted, his mother, Donna Adelson, was arrested and charged as a co-conspirator in the same murder. After this arrest, Rashbaum represented Donna Adelson in her case. Rashbaum told the trial court that Charles Adelson had waived any conflict of interest that might arise from Rashbaum representing both Charles and Donna. But on the eve of Donna Adelson's murder trial, Charles Adelson rescinded his waiver of conflict of interest. This led Rashbaum to remove himself as Donna Adelson's attorney in her murder trial. Now, Charles Adelson claims that Rashbaum's representation of Donna Adelson, quote, infected appellant Charles Adelson's trial, close quote. According to Charles Adelson, his case should be relinquished to the trial court for some type of hearing regarding Rashbaum's potential conflict of interest. Adelson relies primarily on State v. Meneses, which said that appellate courts have the discretion to relinquish jurisdiction to a trial court so that a defendant may pursue a 3.850 claim. The state opposes this motion and asks the court to make Adelson follow the normal route of pursuing a 3.850 ineffective assistance of counsel claim. Adelson's conflict of interest claim should be handled as a post-conviction claim of ineffective assistance of counsel. Adelson's motion fails to explain what he would accomplish by having his case returned to the trial court. Adelson does not allege that a hearing is necessary to establish a claim cognizable in this direct appeal. To further the confusion, Adelson's motion does not state that he is moving under any rule of criminal procedure. Instead, Adelson simply quotes old case law where appellate courts have relinquished jurisdiction for a defendant to pursue a claim under Florida Rule of Criminal Procedure 3.850. The only plausible 3.850 claim that Adelson could make based on Rashbaum's conflict of interest is an ineffective assistance of counsel claim. The best procedure for handling such a claim is a collateral post-conviction proceeding after Adelson's appeal is complete. Adelson's motion to relinquish fails to satisfy the holding in Steiger v. State, which requires an allegation and showing of fundamental error. Adelson's conflict of interest argument is no more than a premature claim of ineffective assistance of counsel. While Adelson relies on Meneses for the proposition that appellate courts may relinquish jurisdiction to trial courts so a defendant can pursue a 3.850 claim, the issue in Meneses was a Brady violation, not ineffective assistance of counsel. The Supreme Court of Florida's decision in Steiger v. State casts doubt on whether Adelson can still rely on Meneses to obtain a mid-appeal hearing on an ineffective assistance claim. 40 years after Meneses was decided, the Steiger court held that, quote, ineffective assistance of counsel claims may only be raised on direct appeal in the context of a fundamental error argument, close quote. The Steiger court also held that a post-conviction proceeding is the proper vehicle for ineffective assistance claims under Strickland v. Washington. Quote, ineffective assistance of counsel claims relying upon the less demanding Strickland standard are properly considered upon the filing of a legally sufficient post-conviction motion in the trial court. At a minimum, Steiger narrows the holding in Meneses by severely limiting the ineffective assistance of counsel claims that may be raised on direct appeal. Adelson's motion to relinquish fails to meet the requirements of Steiger because the motion does not allege fundamental error. To establish fundamental error, Adelson must demonstrate an error that, quote, reached down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error, close quote. Thus, if Adelson wishes to bring an ineffective assistance of counsel claim on direct appeal, he must allege and demonstrate that Rashbaum's conflict of interest caused the jury to convict Charles Adelson rather than acquit him. Adelson's motion to relinquish fails to allege or demonstrate that Rashbaum's conflict changed the jury's verdict. Instead, the motion merely claims that, quote, Rashbaum's conflict of interest infected appellant Adelson's trial, close quote. The Florida Supreme Court's decision in Steiger makes clear that this allegation of infection is insufficient to warrant the relief Adelson seeks under Meneses. At best, Adelson's claim that Rashbaum's conflict infected Charles Adelson's trial alleges a, quote, reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, close quote. The Steiger decision requires Adelson to raise this Strickland claim in a collateral post-conviction motion. This court should refuse to exercise discretion to relinquish jurisdiction. The Meneses Court made clear that an appellate court's authority to relinquish jurisdiction is discretionary. Meneses held that the filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. The Meneses Court also noted that, quote, the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis, close quote. Adelson's grounds are speculative and therefore frivolous. Even if this court could relinquish jurisdiction under Meneses, Adelson has given this court no reason to do so. Adelson's motion provides this court with no blueprint for how his case would proceed if placed back in the trial court. At a minimum, Adelson's motion should have demonstrated two things. First, that further proceedings in the trial court will reveal that Rashbaum had an actual conflict of interest. Second, Adelson should explain why his conflict of interest claim would not be better addressed in a post-conviction motion. Because Adelson did not raise his conflict of interest claim in the trial court, Adelson cannot raise Rashbaum's conflict of interest on direct appeal unless Rashbaum had an actual conflict of interest. Quote, in order to establish a violation of the Sixth Amendment, a defendant who raised no objection at trial must demonstrate that an actual conflict of interest adversely affected his lawyer's performance, close quote. However, quote, an actual conflict of interest means precisely a conflict that affected counsel's performance, as opposed to a mere theoretical division of loyalties. Adelson's motion is insufficient because it cites the possibility of a conflict of interest, but does not hint at how that conflict prejudiced the outcome of his case. But, quote, the possibility of a conflict is insufficient to impugn a criminal conviction, close quote. The Supreme Court explained the reason for this and how even a trial court's awareness of a potential conflict is insufficient for a Sixth Amendment violation. Quote, the trial court's awareness of a potential conflict neither renders it more likely that counsel's performance was significantly affected, nor in any other way renders the verdict unreliable, close quote. In fact, a potential conflict can work to a defendant's advantage by ensuring that a jointly represented co-defendant does not cooperate with law enforcement. Such joint representation may provide, quote, a common defense that gives strength against a common attack, close quote. The facts alleged in Adelson's motion are insufficient to even support an ineffective assistance of counsel claim, quote, until a defendant shows that his counsel actively represented conflicting interests, he has not established the constitutional predicate for his claim of ineffective assistance, close quote. The Florida Supreme Court in State versus Alexis held that, quote, showing an effect on counsel's performance is essential to showing an actual conflict of interest. A theoretical conflict is almost always present in cases of multiple representation, close quote. At best, Adelson alleges a theoretical conflict of interest that would be better explored through the normal post-conviction claim process. This would allow the lower court to hold a hearing on all of Adelson's post-conviction claims at once. The record contained in Adelson's own appendix shows why Adelson's conflict argument is premature, and therefore his motion should be denied. Both Charles and Donna Adelson waived any conflict arising from Rashbaum representing both co-defendants during separate trials. But before jury selection in Donna Adelson's case, Charles Adelson revoked his waiver of the potential conflict. During that jury selection, Attorney Laurel Niles, Charles Adelson's appellate attorney, stated that when they received a subpoena for Charles Adelson's trial testimony, they spoke to him about invoking his rights. Niles recognized that a potential conflict would only arise if Charles Adelson took the stand as a state witness and faced cross-examination from Donna Adelson's attorneys, particularly Rashbaum. Niles stated that, quote, the potential for conflict was always there, but the conflict arose. It's going to arise on the witness stand. It has not quite yet arisen, but potential for conflict is there. Close quote. Thus, even during the hearing, which resulted in Attorney Rashbaum's removal from Donna Adelson's case, Charles Adelson recognized that there was a potential for a conflict if he testified, but Charles Adelson did not assert that there was an actual conflict. In his motion to relinquish jurisdiction, Charles Adelson appears to rely on the fact that both the state and Rashbaum listed Donna Adelson as a witness for Charles Adelson's trial. Rashbaum, however, removed Donna from the witness list before Charles Adelson's trial began. Charles Adelson's motion speculates that, quote, that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interest, i.e., in not being interviewed by the state, and against Charles Adelson's interest, i.e., a witness that could have corroborated Charles Adelson's testimony was not called by Mr. Rashbaum, close quote. This speculative claim is a poor reason to put this appeal on hold and send Charles Adelson's case back to the trial court. Adelson cites an October 12, 2023 motion hearing where attorney Maricel Descalzo appeared on behalf of Donna Adelson, who was then a potential witness in Charles Adelson's trial alongside her husband, Harvey Adelson. Attorney Descalzo had concerns about the state seeking to interview Donna and Harvey Adelson. Rashbaum, then representing Charles Adelson, explained to the court that he had included Donna Adelson on his witness list after the state had sought to interview her. Attorney Rashbaum believed that the state had sought to intervene, Attorney Rashbaum believed that the state had sought to interview Donna as a, quote, end run around the discovery rule. Rashbaum complained that the state had years to interview Donna Adelson, but only sought an interview immediately before trial. Rashbaum stated that he would remove Donna from the witness list if she was not going to be interviewed. But Rashbaum added that he listed Donna as a witness, quote, as a protection for myself to put them on there, close quote. The court asked if anyone was planning on calling Donna Adelson, and Rashbaum explained that he did not intend on calling Donna Adelson. Rashbaum further accused the state of gamesmanship, claiming that the state did not intend on calling Donna, but instead they were trying to get an interview now on the eve of trial, frankly, to figure out what my defense is. The prosecutor, Ms. Kappelman, responded to Rashbaum's accusations, stating that Donna and Harvey Adelson had never made themselves available for an interview. Kappelman said that she reached out to the Adelsons to, quote, nail down the fact that they were going to invoke their Fifth Amendment right against self-incrimination, close quote. Donna Adelson responded that she was going to invoke the Fifth for pretrial purposes, but not for trial. This response led Kappelman to believe that the Adelsons were going to testify for the defense. Kappelman stated that she was seeking to interview Donna and Harvey Adelson prior to trial to see if they were going to invoke, but she did not know she would call them because they never made a statement. Thereafter, the parties stipulated that neither the state nor defense would call Donna or Harvey Adelson as a witness. Thus, the record shows that Rashbaum did not remove Donna Adelson from the witness list to protect her interests and thereby undermine Charles Adelson's defense. In fact, Attorney Rashbaum had never intended on calling Donna Adelson as a witness. Instead, Rashbaum only listed Donna Adelson as a defense witness when he learned that the state was intending on interviewing her. Rashbaum believed that the state was attempting to avoid discovery and gain insight into Charles Adelson's defense. These facts fail to show that Attorney Rashbaum changed his defense strategy to benefit Donna Adelson to the detriment of Charles Adelson. And even if Rashbaum had intended on calling Donna Adelson as a witness, there would only be a conflict if Donna Adelson's defense was detrimental to Charles Adelson's case. There is no evidence of that. Rashbaum's representation of both Donna and Charles Adelson was no more conflicted than the dual representation at issue in State versus Alexis. Alexis and co-defendant Guerriere were represented by the same attorney at trial. The victim and another witness testified that Alexis or Guerriere had pulled the victim out of a car and pointed a gun at him. Guerriere had made a statement at trial that both he and Alexis had asked the victim to get out of the car, which was occupied by a female friend of theirs, and Alexis had pulled him out of the car. Both defendants testified at trial that they had jointly pulled the victim out of the car, but neither displayed a gun during the encounter. The state had argued that, quote, since the co-defendants' respective defenses were compatible rather than conflicting, they both admitted pulling the victim from the car, they both denied being armed, and neither claimed the other was armed, that dual representation did not create a conflict of interest between respondent and his attorney. The Florida Supreme Court agreed there was no actual conflict of interest. Conclusion. There is no reason to delay this appeal any longer. If Mr. Adelson wants to immediately pursue his post-conviction remedies, Charles Adelson should dismiss this direct appeal. If Adelson does not immediately want to pursue the post-conviction claims, he should continue with this direct appeal and file his post-conviction motion when this appeal concludes. The state asks this court to deny Adelson's motion to relinquish jurisdiction. Respectfully submitted, Ashley Moody, Attorney General, signed by Tricia Meggs Pate.